Harrington here. Happy Father's Day. I know it's belated. I try and do these videos about a week ahead of time, so I'm in the spirit now. So happy Father's Day. Now, I was trying to come up with some dad-related legal topics. I thought that'd be the way to go today. But it's hard because, the law's for everybody, right? I guess I could go into maybe probate, but that seems kind of dark. I thought maybe divorce, but there's a reason I don't do that kind of law, and it's too much drama for me. And then I hit upon it. Over the years, rather sadly, one of my party tricks has become talking about some of these cases that I studied in law school that are interesting and or funny, often ridiculous. And then it struck me that, you know what? The best ones are things that only guys would do. So that's what I'm going to talk to you guys about today. You'll let me know in your comments whether this is a good approach or not. But these are just like funny or interesting cases. They actually do stand for principles of the law. Some of these cases are fundamental to the evolution of American law, American property law in particular. So, let's just dive into it. You guys let me know what you think. Here we go. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Let's start with Post v. Pearson. This is a classic and very important in American property law, and something the only two dudes would do. So Post is out hunting. He's hunting fox in particular. He spots one. He shoots it. He injures the animal but doesn't kill it. So it's limping away and he's in pursuit of the fox. Well, the fox finally collapses at the feet of his neighbor, Pearson. Pearson picks up the fox, finishes it off, cracks its neck, and then the dispute begins. Post says, hey, that's my fox. I shot it. I was in pursuit of it. Pearson says, I finished it off. Well, you would think that being a couple of guys, they would just, take care of business right there, sort it out. But no, they're not savages. They took it to the court. I wish these videos weren't so short. I could give you a chance to kind of think this over. I mean, whom do you give it to? Post or Pearson? I mean, Post did most of the hard work, right? He found the fox. He shot the fox. He injured it mortally. But Pearson actually, did the chiropractics and finished it off. So to whom do you give the fox? Well, the court gave it to the chiropractor. Spoiler alert. And this becomes an important premise in American property law. I don't mean real property, I mean possessions law. Okay, let's stick to the hunting theme. Okay, so this is actually an English case, but it's fundamental to American property law because, of course, we derive our law from England. Keeble v. Hickeringill. All right, so this dude has a pond, and he has set it up so that he can capture ducks. I don't know what he kills them or just captures. I guess he just captures them. I don't know. Remember, I went to law school 20 years ago, so I don't have the details fresh in my memory. Anyway, so he has this pond, and he sets up decoy ducks, and then when the ducks fly over and they land in the pond, he's got it all set up with traps and stuff, and he captures them for it's a business. It's he sells them or does some sort of commercial enterprise. Well, he's got a neighbor, dude, obviously, and with too much time on his hands, clearly. And this guy dedicates himself to waiting for the ducks to fly in, and then before his neighbor can capture them, he shoots off a shotgun. He's not necessarily trying to kill any of the ducks. He just wants to scare them off. So again, they're not savages. They take it to the court. What would you say? The claim was that the neighbor with the shotgun was interfering with a commercial enterprise, interfering with his business. What do you think? Well, sure enough, the courts rolled with that story. This was tortious interference with a business enterprise. So yeah, the guy with the shotgun lost the case. While we're on the topic of shotguns, let's do one more and then we'll switch to sports. Catco v. Briney. Now this was in Idaho, but it, for all the world, seems like it should have been in Florida. This guy has like a cabin or it's an abandoned house. It's like in the middle of nowhere. And so, as a security measure, he sets up what's called a spring gun. He booby-trapped the front door with a shotgun. He put a shotgun with a string so that whoever opens the door gets blasted. That was his security system. Well, naturally, somebody does go waltzing through the door and does get blasted. Not killed, but blasted. And the lawsuit ensues. Well, to whom do you give it? Does the guy have a right to protect his private property? The dude who walked through the front door was a trespasser, right? So, who wins that lawsuit? Now, if this case had been in Florida, it may very well have been a different result. But I guess maybe the Iowans are a little more civilized, and the court decided that no, you can't booby trap your house and use mortal force to protect your property. It's interesting because, of course, here in Florida, we famously have the stand your ground law. So those two things seem to be at odds. Okay, so let's call that part one. I forgot to announce it. Part one, I guess that's the blasting, the shotgun themed cases. Let's go on to part two. Let's turn to sports now because, that's a guy thing. All right, so this still lives in my nightmares. I was coaching my kids' soccer team, and this is not like travel soccer teams. They're not very good. And it was mixed up, guys and girls. There's this one girl, she was like a foot taller than everybody else. She looked like she was 2 grades ahead, and so they put her at the goalie. That was the opposing team. And then here comes my son, and he kicked the ball so hard, caught her right in the grill, got the whole snapback effect. The face went beet red, the tears, the whole bit. It haunts my dreams. Well, this actually happened. There was a case about a goalie getting struck in the face and then suing. Okay, well, this actually leads to a line of interesting cases, and we're gonna explore the theory between, what is an assumed risk and when does it become legally actionable. All right, so sadly for the little girl and also for the high school kid that got kicked in the face with a ball, not sadly, but they were found not to have a cause of action. In other words, there's nothing they can do about it. They can't sue anybody because they are voluntarily participating in the sport. And, sadly, getting kicked in the face with a ball is part of the sport. And we see it in other sports as well. If you guys watch American football, have you ever seen the dudes holding the signs on the sideline, or sometimes the referees or the cameramen? They sometimes just get wiped out. I suppose the same thing comes up in NASCAR and certainly golf, which we have some golf cases to talk about. But anyway, you get the idea. We can't have people suing every single time that there's a sports-related injury. So the courts say, no, sometimes you're a willing participant and you assume that risk voluntarily, so you cannot sue anybody when you get hurt. Now, contrast that, however, with a similar soccer case where the goalie has the ball in his hands. He'd already secured the ball, and then this player, we'll just keep it simple, a player, came up, and whilst the ball was in his hand, he kicked and broke the goalie's jaw. Okay, the goalie didn't sign up for that. So that case was actionable. So now let's explore that fine line between like an errant golf ball striking a fan in the head, which happens fairly often, right? Can that fan then sue? Versus a burst of anger, a golfer breaking a club on purpose and somebody getting injured that way. Professional golfer Kevin Stadler broke his driver in a fit of anger. He was unhappy with that drive. Breaks the driver, the top part with the head, goes spinning off into the crowd and strikes a dude in the head and causing injuries. He required 6 or 7 stitches, something like that. Well, we kind of just said that, if you're in the gallery, you're standing, you're a spectator, and a golfer hits a bad shot, and you get struck in the head or struck wherever with a golf ball, there's nothing you can do about it. You voluntarily stood there, you wanted to watch, you got a view, got a nice view of that shot in 3D. So those accidents are not actionable, meaning you can't sue. However, the guy that got hit with the club head, the Kevin Stadler club head, he could sue. What's the difference? Well, I guess it has to do with recklessness, negligence, willful. The golfer that hits a bad drive and catches somebody in the leg with his ball, 300 yards down, that wasn't willful. He certainly didn't mean to hit a bad shot. It just happened, and you, the spectator, chose to stand right there, so you assume the risk. However, Kevin, on the other hand, that was quite willful. That was quite reckless, what he did. So one's actionable, the other's not. Let's just keep it official here. So if you want to look up these cases, it's Petrie v. Empire Fire and Marine Insurance Company. They're the insurance company. So that was a spectator who got hit by a ball, an errant shot. And then there's Robinson v. Crowley. That was in Minnesota. Similarly, a spectator got hit by an errant ball. Nothing they could do about it, and no insurance claim either. On the other hand, and I don't have the case number, I couldn't find the case. AI couldn't pull it up. But I do remember from law school, this dude was out on the course and he got angry, which is wont to happen on the golf course, hits his club against the tree. The club breaks and the part with the head goes flying, but it does this weird sort of, it's a weird flight. It does like a boomerang effect and it bounces off a golf cart, comes back and strikes him in the chest. And then this jackass, you can see the type of personality we're dealing with here. This jackass tries to sue the golf course. Father's Day theme, right? Only a dude would try something like that. And as you can imagine, not actionable. Threw that case out of court. Now let's get into some gray area. Let's just call this part 3 because that's the way I tend to format these podcasts anyway. So this is part 3. We're going to get into the gray area because it might seem very cut and dry to you, talking about, intentional things versus unintentional things. That seems pretty easy, but there is plenty of gray area, and we have some recent examples of that. This happened in 2020. Djokovic at the U.S. Open. You probably have heard about it. So, he loses the point. He's unhappy with the way the point went. I can tell you I understand that feeling. And so he hits the ball in disgust, a little harder than one normally would, towards the back wall. Okay, well, naturally, he catches this line judge right in the neck with the ball. I'm going to get a little hate for this part, but I'm going to say it anyway. The lady goes down like she's been shot. She's clutching at the wall. She's dying. She puts on quite a show. And so, what happens in that scenario? Djokovic, yes, he kind of smacked the ball harder than he probably should have. He didn't, fire it 100 miles an hour, but he hit it harder than he normally would have in disgust. But nobody would say that he was meaning to hit this lady in the neck. And then you could also, isn't the line judge just like a cameraman at an NFL football game where, you assume a bit of risk, you might get wiped out. You might get hit by a tennis ball. Well, you guys may already know what happened. It didn't go to court. Actually, the tournament disciplined Djokovic, and the ATP did as well. They disciplined him. Some would say rather harshly. He missed a couple of majors, and they took away points and money, and it was pretty severe. So we don't have a judge opining on that one. I'll leave it to you guys. Maybe go check it out on YouTube and see what you think. Obviously, Djokovic didn't mean to hit the lady. Should he have, hit the ball in disgust like that? Maybe not. But on the other hand, she is a line judge, and I don't know. I'll tell you one thing, the line judge putting on the kind of show that she did, she acted like she'd been shot, like she was cashing in her chips. Maybe that made a difference, to tell you the truth, because we have a very similar incident that just happened at the last French Open, 2025 French Open. Musetti, the dreamy Italian player, he didn't hit the ball with his racket, he kicked a ball and actually hit somebody with the ball. So, but the result was wildly different. Nothing happened to him. So then maybe we have a little inconsistency there. Although I tend to, look, the line judge who got hit by the ball that was kicked by a Musetti, didn't put on a whole spectacle. And the lady that got hit with Djokovic's ball certainly did. So, should we be considering that when we're taking into account what's the correct result in terms of the law or in terms of discipline? I don't know about that. Okay, I got one more for you guys and then we'll call it. So this one is Paul's graph. This one's a very famous case and some stuff that only a guy would do. All right, we got this dude. He's trying to get a package. He's running to the train station, right? He's trying to catch a train, and being a guy, he's late. And so he's running with his package, and now he's chasing the train, trying to get onto the train as it's pulling away from the station. This is back in the day, so we got the conductor trying to be helpful. He's like reaching his hand out to try and help the guy get up onto the train. Okay, so a couple of guy stuff right there, right? Naturally, the dude with the box falls. And naturally, the box contains explosives. Yeah, they were fireworks. But again, this is way back in the day, so he's basically carrying a box of gunpowder. Okay, here's where things get interesting. So the explosion occurs, right? There are no severe injuries to the dude who was running with the box. Amazingly, I don't know how he got out unscathed, but at least the case is not about his injuries. I suppose there's no question that if he's injured, it's his own damn fault. The conductor doesn't get hurt either. What happens is, bizarrely, the concussion from the explosion caused like one of these old grandfather clocks, this huge clock that was just sitting on the platform, to fall over onto poor Mrs. Palsgraf. This is a real case. You guys got to look this one up. And it's a very important case in American law having to do with negligence. It's tort law. Okay, so the case ends up being all about Palsgraf suing, everybody. Everybody involved. The station, the conductor. Why is he trying to help this guy make the train? The guy who's running was explosive. I mean, everybody was negligent, right? Everybody was negligent to some extent. And of course, these are events that can only take place with dudes involved. Let me pause. Whom do you give it to? Does Palsgraf have a case? I mean, I can't remember if she died or just got injured, but pretty severely injured. Like, this was a big clock that fell on her. Well, I know what you're thinking. If you're like most people, you're like, well, she's got to have some recourse, right? I mean, she's just standing there. And we got all these people doing stupid stuff, so she's got to have some recourse. Sorry, my friends. Palsgraf gets nothing. No recovery for her at all. And the reason is that the injury is too remote, too unforeseeable. I mean, the guy carrying the explosives and running to catch his train, yeah, that was stupid. He shouldn't be doing that. But could it possibly have been foreseeable that action, as negligent as it might be, would result in a clock falling over on some old lady? Same thing can be said for the conductor who tried to help the guy up, tried to pull him up onto the train as it was pulling away from the station. Dumb thing to do, but there's no way he could predict that would result in Palsgraf, who's standing there on the platform, getting hurt. And likewise, the train station itself. I mean, I guess you could say, why didn't they fasten that clock to the wall? To me, that seems like a decent argument that the clock should have been secured, right? But, again, it's back in the day. And the court found that the connection was the causal link between all the dumb events that ended up with poor Mrs. Palsgraf getting hurt. They're just too tenuous to sustain a negligence action. So that's what I got for you guys today. I had fun. I hope you did too. You let me know if you want me to do more of this, because God knows there's some crazy cases that we could talk about. A lot of them are just fun and quite ridiculous, especially the ones involving guys, especially the ones involving Florida. So if you like this episode, let me know. I'll try and do more of these. And recuerda que hablamos español. It is Father's Day. I mean, throw me a bone, guys. Give me some likes. Give me some comments. I mean, it's my day. All right. See you next time.